Ladies and gentlemen, have you arrived at a verdict? If you'd hand it to the bailiff, please, or the sheriff, please. All right, ladies and gentlemen, your verdicts are in good form and will be accepted by the court, and I'll announce your verdict in just a second. All right, ladies and gentlemen, in the audience, I am acutely aware that your feelings are on edge, that there's a great deal of emotion involved, and I certainly can understand that, and everyone that participates here can. But the court cannot tolerate and will not tolerate any verbal outburst, any display of emotion whatsoever. So you're cautioned and warned as I read the verdicts that you are not to show any outburst, any emotion, or any display. And I recognize that that's difficult, and that's why I'm warning you in advance. The verdicts read as follows. We, the jury, find Jessie Lloyd MISSKELLEY, Jr. guilty of first-degree murder in the death of Michael Moore, signed by T.J. Williams, foreman. Is that your unanimous verdict, ladies and gentlemen? Yes. All 12 of you agree. Gentlemen, you want the jury to be polled on that verdict? Yes, sir. All right, ladies and gentlemen, we're going to go through a procedure called polling the jury, which simply means that when your name is called, if this is your verdict, answer yes. You ready? Do you have the jury list? I'm sorry, I probably didn't tell you. While the clerk's getting the jury list, I'm going to read your other verdicts. We, the jury, find Jessie Lloyd MISSKELLEY, Jr. guilty of second-degree murder in the death of Stevie Branch. We, the jury, find Jessie Lloyd MISSKELLEY, Jr. guilty of second-degree murder in the death of Chris Byers, again signed by T.J. Williams, foreman. Are those verdicts your unanimous verdicts? That is, all 12 of you agree upon each finding. Right. And in just a moment, when the clerk returns with a jury list, I'll ask her to call your name. And if these verdicts, all 3 of them, reflect your individual finding, then you should answer yes as your name is called. And while the clerk is bringing the jury list, I might explain to you that your findings, which the court has accepted, will require you to return to the jury room and consider the punishment. Before we do that, food has been ordered and it should be here for you. And I'm going to ask that you take a break for lunch. Take whatever time you need to rest and enjoy the food that's being provided. It won't be much. And after that, then we'll reconvene and I'll give you further instructions, and possibly, if the lawyers care to, there may be brief arguments or brief presentation of additional facts. That may not be necessary. It depends upon my discussion with the lawyers. So I'm going to let the clerk poll the jury at this time. So if these represent your individual verdicts, please answer yes as your name is called.
Carla Price.
Yes.
Stephen Green.
Yes.
James Rainwater.
Yes.
Teresa Burgess.
Yes.
Ronnie Smith.
Yes.
Lloyd Champion.
Yes.
Margie Woods.
Yes.
Donna Ludina Moore.
Yes.
Janet Luder.
Yes.
April Lunsford.
Yes.
Audrey Dacus.
Yes.
T.J. Williams.
Yes.
All right, ladies and gentlemen, your verdicts will be accepted by the court as the verdict in this case, and at this time you'll be allowed to recess, and I'm going to keep this area back here where you have coffee, cold drinks, and food coming. If you want to go outside the back to smoke, I'm going to provide deputies out in that area. That'll be fine. But you may stand in recess for, let's say, 30 minutes. Will that be sufficient time? All right, you may stand in recess for 30 minutes. Gentlemen, I need to see the lawyers.
I'm sorry.
That's all right.
I
I should have warned you.
We were locked in, couldn't get out.
Yeah, I should have warned you. Don't worry about it. Gentlemen, can I see the lawyers at the bench? I thought that's a reasonable results, basically. You know, I can follow their logic in those results. What I need to know from y'all, first of all, I don't.
You don't want to be. I don't know if you want to be or not.
No, I don't really. Okay, well this one's Barbara. She needs to hear. Yeah, Brent. I guess under our new law, you're entitled to put on aggravation or mitigation. I don't know whether it's really necessary with these findings, but I think that if you want to, you're permitted to do so. I'm not sure of the effective date of the new bifurcation.
I thought it was effective for crimes that occurred
After that, that's what I thought too. But now, so I'm not sure that it's even appropriate or applicable.
What they're telling us out of the prosecutor's coordinator's office is that it's applicable to crimes that are tried after January 1st.
Which means that you could do aggravation or mitigation.
Right. The biggest thing that, there is an instruction that they prepared that instructs the jury on parole eligibility and that sort of thing. I hadn't even given that any thought.
Well, that's why I took the recess, because I haven't either, and I hadn't even read that material. I'm sure most of y'all had. And I was on the
discussed this matter with several attorneys, and it was my understanding that we had the option of opting in or opting out.
Well, that's kind of what I thought too, but I don't know.
I don't feel any need to go into the mitigation.
We want to opt out. Just go to the old
Just
system.
opt out since the crimes were allegedly committed in May of '93.
Well, y'all want to do a little research on it and call and find out what you want to do, and just let me know whatever one of you wants to do. Then, hey, now, by the way, do y'all have any verdict forms that fit this situation? Because I'm not sure you gave me any.
I don't think that's going to get entered today, Your Honor. Quite frankly, I don't think we have one written.
We got a book. Let's go get some.
Well, I need verdict forms
Okay,
too
all
that
right.
provide for.
Okay, I don't have any prepared.
Something matter type it up. We get a type it up.
Okay, all right, Your Honor.
What is it, Class B? Two Class B?
In a Class A. Just let me instruct that the range of punishment on first-degree murder is 10 to 40 years or life.
Put on some argument, it'd be real brief.
I don't want to.
Reject, Your Honor.
Well, that's why I want y'all to find out. I won't find.
Well, even if that doesn't apply, you've always got the right to argue punishment.
Yeah, we didn't have the right to until
No, we would submit that under the existing law at the time these acts occurred.
Well, but I think since it was bifurcated, I think you're both entitled to a 5 or 10 minute argument as to what the appropriate punishment is.
But they didn't come back with a conviction of capital murder.
I know, but you neither of you have really argued the law as to punishment in any of these things.
We'll look at the law, Your Honor.
Okay. Well, sandwiches, y'all don't need to leave because I ordered 99-cent quarter pounders for you.
I just need like 4 or 5.
we can leave.
Well, yeah, if you want to, but I mean, I told them 30 minutes. I can keep them out an hour.
30 minutes to eat.
Yeah. 40 of them. They were just 99 cents. Hell, that's the best deal we've had. No, not really. You know, and really I can follow their logic. Their thinking was that he directly contributed to the death of the Moore boy and indirectly to the other two, and that's not completely inconsistent with the facts, you know. I mean, I can understand it. And they probably decided that we're not going to consider capital because You know, the only thing they had is his own confession. And that's, I think those verdicts are logical.
Right down the line, you know.
Is the new law codified in the criminal volume? Anybody even know where it's codified?
No, I don't. I'm gonna be honest. I got something in the mail about a new proposed instruction. I didn't even bring it with me.
It was my understanding, Your Honor, that it applied to.
Call that thing in that office that they established up there and find out what their thought on it
That's
is.
criminal resource center?
Yeah.
Do you have a number for that?
What John was saying is they didn't argue.
No, they hadn't. I'm gonna let them argue punishment. I'm gonna let you argue punishment anyway because you haven't done that. I'm gonna give you like 10 or 15 minutes each. But now, as far as calling victim witness, well, maybe what they want. That's what I'd do.
I don't think anything we can like it now is going to make it any difference. And I don't believe anything we argue now is going to make any difference. They've been back there for 12 hours, 10
Well,
hours.
they need to have it explained to them what it is they're doing.
I think we need to understand the range of punishments.
That's what I'm trying to say.
As far as doing a bifurcated mitigation aggravated, we would object to that and say that that's not the law or that it was in effect at the time of the murder.
Yeah, but that wouldn't have anything to do with punishment, just arguing punishment, because you hadn't done that technically. You know, they weren't supposed to even consider it, and y'all didn't.
Under the old system, since they didn't come
No,
back.
we would have done the same thing under the old system. If they came back with a lesser included offense, you would argue punishment. I've done it before. You just argue punishment. You don't bring on evidence.
Or you're going to call witnesses.
Yeah, I didn't see his reaction at all. What did he have any?
I wasn't looking at it. I didn't see it.
Are you disappointed with that verdict?
Yeah, a little bit, but I think it was.
Boy, it's probably compromised, but
Yeah, but I think that what they got hung up on is saying, well, he said this is all he did, and thinking they couldn't go beyond that.
well, I think that's probably true.
Well,
I mean,
no.
I think that's probably what they did do. Is what I'm saying.
And what I think would have argued maybe is, ladies and gentlemen, just suppose that we didn't have a confession, and all that we had was a fingerprint, this defendant's fingerprint on the neck or on the shoulder of one of these kids. Would you expect to say he's not guilty or guilty of a lesser offense simply because we couldn't show exactly what he did?
Yeah, well, the other thing is, and I thought you argued it, was that just because he said that's what he did didn't mean he didn't do more.
Yeah.
Well, I mean, that was the argument. That's the argument you made.
There's nothing in evidence to suggest that.
Sure. Then you got 3 weapons, you've got all kinds of things.
Take it off.
I mean, that would be like saying if all you had was evidence that put the person at the scene of the crime, that you couldn't convict because you wouldn't know what he did. And that's not. I mean, Judge Burnett did one where all you had was a thumbprint on a.
Yeah,
Dome
Hogan, wasn't it? Yeah.
That's all.
It's the only evidence we had. We had some vague circumstantial evidence of a witness that claimed they saw a man that fit his description at a convenience shop in Memphis at the same time the victim was there.
And this guy went to the penitentiary with a
Yeah, went for life without parole. Yeah,
How could you guys sleep at night?
I was just good.
Didn't have any problem at all, huh?
No, I didn't, as a matter of fact.
The perspective of
This
where you
guy
are
was
in
bad news. He was, that was the case where we had that piece of cable tie,
I remember hearing about you beating on the jury
and
rail.
I would bang down on the jury rail, and he'd go wham, and he'd jump back, and says, as he beat her unconscious.
They have the obligatory what does both sides think about the process.
Process of what?
The process. I'm a believer in the American justice system.
Let me wrap myself with a flag first. I don't have any comment there right now. I'm just throwing out what I think.
I'm gonna save it for, you can't give me a sentence. You can give me a sentence, then we can.
Well, it probably wouldn't be appropriate for me to comment since I've got another one to go.
Yeah, that's right.
Yeah, and also they haven't fixed punishment yet, and that's an integral part of the process. So probably it's a little early for them to either be elated or discouraged, or ambivalent or indifferent. And John's right. He and I can't make any comment because there's 2 co-defendants yet to be tried. So I don't want to comment. You know, the jury heard it and announced their decision. That's all that matters to me.
Is that the new code? The one that just came out?
Yeah, I'm sure that's
Did I give y'all enough time to get hooked up?
Yes, sir.
Is there any disturbance outside? Any problem? On a feeding frenzy. They love.
Comment on any others who get another trial. Off the record, I wouldn't go through the trial. Well, no, I wouldn't sure somebody would try it.
Well, Barb, here's one that we just got, another murder case we just got affirmed on. Maurice Coleman, do you remember him?
I remember somebody got a 7-month extension that he didn't need. That's what I remember about that one.
I'm in trouble. I shouldn't have mentioned this one. That was Bill Ross's case.
Well, of course.
Yeah, he's the only one I ever give extensions to, isn't it?
Well, why did you do that?
Did you hear about the murder case Fred just tried? Got
Yeah, I heard.
life and some juror saying that it was only 8-3 or 8-4, 9-3. And they filed some kind of affidavit asking for a new trial. The jury said it wasn't unanimous.
Well, Sam might grant it. You know, poor Fred.
I know.
Did you say about a recess? I didn't know.
I gave the jury a 30-minute recess.
Probably going to be long.
It's probably going to be longer than that because none of us really know the status of the new procedures on mitigation, aggravation, victims' witness impact statements, and all of that sort of stuff. You know, we knew how to handle it if it was a capital murder finding because that you've got strict instructions to follow on that. The question is whether or not they get to put in additional evidence or not. Now, they're going to each get to argue briefly their version of punishment. But whether or not we take additional testimony depends upon how we decide, how I finally decide the new law, whether it's applicable or not. If I decide that it's not applicable to this case, then the lawyers will get a few minutes to argue punishment, and I'll simply read a statement to the jury that the range of punishment is X number or whatever, you know.
You still have to deal with it.
Huh?
You still have to deal with
Yeah.
it. Are you going to do that out here? Or
Sure, right. Oh, yeah, right here.
But you think it'll be longer than 30 minutes?
Yeah, I really do, because we're having to call there's 2 theories of thought. Whether or not, one is it applies to trials that occur after January the 1st, or if it only applies to trials that were committed after January the 1st. I think it probably means anything that's tried after January 1, they can do additional testimony if they want to. Because all of our trials are going to be bifurcated. I try to explain that to you. The reason for that is to allow the defendant to have the opportunity to put in things that would have otherwise been inadmissible to mitigate the crime, and to allow the state to put in things that would have been prejudicial and inadmissible to show that the person had either a history of bad acts or proclivity to crime or things of that nature. Plus, victim impact statements will be allowed. And none of us really know whether it's applicable to this case because it occurred prior to the passage of that bill and so forth. So, but in any event, they'll get to argue punishment because that hadn't been done.
First degree murder, what's the range of
10 to 40 years or life.
If each one of these folks out here are saying, the parents of these victims are all saying they want to say something to the jury, are you going to limit it if you do allow victim impact statements?
Well, if I decide that they're applicable, then I'm going to leave that to the lawyers. I don't dictate what they put on, what they don't put on. I mean, how in the world can the judge be the one that decides who gets to, make a statement to the jury? I mean, that'd get a little out of hand. That's got to be controlled and handled by the lawyers involved in the case. And I'm not going to. I'll either permit it or not permit it.
In looking forward to this case,
Am I looking forward to it? Was that a question? Not.
Is there any way before you get to actually present the information on the sentencing? Before you go to the sentencing phase, an agreement could be reached with the defendant to lessen the sentence and return for testimony in the next trial. We talked about this a little bit yesterday. Or is that something that doesn't even get done?
That's something you need to ask the lawyers about.
Is that a possibility?
Am I being quoted on this?
I'm trying to find out what the process is.
Well, not for the record. I assume that could be a possibility, but it wouldn't be within my purview or my prerogative to say one way or the other. That'd be something that they'd have to initiate and they'd have to do, and then they could approach the court with it. And yes, that's a possibility.
They'd have to do that before they make
They'd
their
have to,
arguments.
they'd have to do that, and they'd have to come to me, and then the court would have to ratify whatever their agreement was, and then you could proceed. But my speculation on it, and again, it's not for the record, is that's very unlikely.
That they what?
That's very unlikely. So what would you,
Well, no, I don't know. My editor's asking a question. So I'm saying,
there are 1,000 different variables that you could come up with.
What are you drinking, Gary?
Diet Coke, I've got one.
We'll get it.
Oh, thanks. Did that work out?
As far as I know, everybody was happy. We had you live in Memphis. I know Jonesboro had you live. So thank you very much.
Okay, y'all got it fired up and sent off.
Oh yeah. We'll probably do this penalty phase and then get out here. We will be here with you in Jonesboro, so we'll probably see you in a couple of weeks. Thanks a lot.
Y'all gonna get me eating a cheeseburger at the bench now. Man, alive. You're gonna make this look like country justice or something. The judge eats a cheeseburger.
You're reading it wrong. What is it? Any personal feelings or?
I don't want to comment because there's another trial, and it wouldn't be appropriate for me to make any comment, particularly when I'm going to be presiding over another trial or essentially the same occurrence. So, even though you are going to be printing it way down the line,
That's true.
somebody might subpoena your recording.
Were you surprised, or just as a judge, from what you heard?
No, I wouldn't say I'm surprised. In fact, I can understand their rationale.
I think it's too early to say, until we know what the punishment phase is going to do.
If you look at how the findings were, you can pretty well interpret their reasoning.
What do you think of the verdict?
So, what more can I say?
Eat. Give me a snack.
do it. Thank you.
Do you know where the MISSKELLEY family went, or is it just...
I don't have any idea. Did he say or do anything?
I don't know where they went.
Oh, thank you, sir.
About salt?
No, I'm fine. Thank you. That's a good deal, wasn't it, for you?
Those are 99 cents a piece.
Any thoughts, Mr.
Yeah, here's
Sheriff Staff?
Any thoughts?
I know you have many.
I'm glad it's sober, and I'm real proud of our jails. I think you've done a fine job. I'm real proud of you.
Good security.
I think the sheriff
Did a fine job.
I think the sheriff's done an outstanding job in organizing his security. I'll give him credit where credit's due. Are y'all really gonna film me while I eat this thing?
Take a bite.
It's like chewing gum. I've got this little piece of cheese on my finger that I want to lick off, and I can't do it while you got that camera on.